Subcommittee on Government Operations will come to order, and without objection, the chair is authorized to declare a recess at any time. Before I give my opening statement, if indeed you have to take a cell phone call, we ask that you would step outside and that you move not just outside the rooms there. The acoustics can be very bad sometimes, so we can actually hear your conversation. So if you got to have a conversation or a cell phone call, we ask that you move out and kind of down onto the landing outside this particular facility. Good morning to everyone. I'm excited to be here in a field hearing here in Waynesville at the historic Haywood County Courthouse. In order for this to happen, we had to rely on people here in the county. And it is my great honor to thank Sheriff Christopher and his team and the courthouse staff here. They've been great. I want to not only sincerely thank them for their assistance, but truly for their service to the public each and every day. I also want to thank the public, all of you, for coming out. I hope that you will find that this is a valuable investment of your time and shines some light on the situation. And as we have a great crowd here, I'm very grateful that you would come out, but I also wanted to mention that this is an honest to goodness congressional hearing. And just like the ones that we would have in Washington, D.C. Because of this, we need to treat it like one. And so we'll have two panels of witnesses. Our first panel is here already. We have members of Congress that are here today. They will have a chance to ask them questions. But this is not really a town hall. And so unfortunately, we're not going to have time for opinions to be given from the audience. It's not a forum like that. Hopefully, we will be able to ask questions and have the responses. If you have a burning question that you want to get asked, that you feel like has not been asked, we'll actually hold the record open where either Congressman Duncan or Congressman Collins or myself can actually work together to make sure that those questions are asked for the record. So I would appreciate your cooperation, and even though this could be a very contentious and emotional issue, I ask that you show the rest of the world the kind of southern hospitality that we're used to here in the mountains of western North Carolina. Perhaps the best thing about holding a field hearing is that it gives Congress a chance to look at things that have happened outside of that beltway in Washington, D.C. There are a lot of things that happen on the national news, and yet Operation Something Brewing is a good example of something that's happened here in western North Carolina and North Georgia. As many of you are familiar, back in the 1980s, the federal and state authorities undertook Operation Smoky that stopped some illegal, at that point, harvesting of black bears in and around the Great Smoky Mountain National Park. That was a successful operation that caught a lot of people that were indeed breaking the law. However, about 5 years ago, many of these same agencies began investigating bear poaching again. A new operation was begun, lasting from 2009 through 2013. It covered western North Carolina and northern Georgia. It primarily involved the U.S. Forest Service, U.S. Fish and Wildlife, the Georgia Department of Natural Resources, and the North Carolina Wildlife Resource Commission. It was named Operation Something Brewing. Now, we are joined by representatives of each of these agencies here today. I want to thank them for their time that they came to appear here. But before I continue, I want to make a few things clear. First, I support our law enforcement officers, both state and federal. In particular, I want to thank them for their role in protecting not only lands and wildlife, but the people that they serve. And in some cases, their work can be dangerous, as has happened even recently over in Henderson County. Their work can be very dangerous, and so I appreciate their willingness to endure all those things and the dedication that they show to do that. I also want to take a moment to recognize the hard work of the state and federal prosecutors who try to bring cases before them by the law enforcement officers. They're all keeping us safe and protected, and in this particular case, trying to protect our lands and wildlife. And finally, there have been many instances in the case of Operation Something Brewing where real crimes were committed, and these people need to be punished. We have laws for a reason. We have a criminal justice system that enforces these laws, and those are good things. With this said, though, I do believe that some of the conduct of Something Brewing needs to be examined. Over the last few years, there have been a tremendous amount of media coverage on how this operation was handled. We'll hear from witnesses today and their representatives about the specifics. However, over the years, I've heard complaints about arrestees being entrapped, others coerced into their charges of the arrestees being taken into custody in an extremely aggressive fashion. I've heard about defendants receiving extremely harsh punishment for petty crime offenses, and undercover officers essentially committing most of the hunting violations. I hope that this morning that we can shed some light on how this state federal operation was held. Moreover, if we can find things that weren't handled properly, and I plan on working to improve the system and prevent mistakes like this from happening again in the future. Now, I'm pleased today to be joined by some of my colleagues that are not just colleagues but friends. Congressman Jeff Duncan from the great state of South Carolina, and I would like to say our hearts and prayers are with you and your state over mourning the loss of this tragic event that just happened. But I want to thank Congressman Jeff Duncan for being here. And my good friend Congressman Doug Collins of Georgia was willing to come up today. Some of this happened actually in his particular district as he represents much of the mountainous area of northeast Georgia, I guess officially. So without objection, they are welcome to fully participate in today's hearing. I recognize Congressman Duncan for an opening statement.
Well, I thank Congressman Meadows for inviting me to participate. Just since I learned about Operation Something Brewing, there is a number of questions that I hope to get answered by participating today, both from panel 1 and panel 2. I sit on the Natural Resources Committee. I also sit on Homeland Security and Foreign Affairs, Lacey Act issues, and Natural Resources Forest Service, and U.S. Fish and Wildlife Service jurisdiction falls under Natural Resources. So I am very interested in this. I appreciate the Congressman also recognizing South Carolina at this very difficult time for our state with the tragic loss of life, and I would ask everyone to please continue to lift my state, the city of Charleston, and the folks at Emmanuel AME Church in your prayers. And with that, I go back.
I thank you. The chair recognizes the gentleman from Georgia, Mr. Collins.
Thank you, Chair. I appreciate that, and it's a pleasure to be up here across the border. We share this border, and I think it is one of the reasons people, when they come here, they stay here. Because this is great for North Carolina and Georgia, as we have a great part. And of course, my friend from South Carolina, we share another border. So we got this area pretty well covered. And again, the prayers are with me to go to South Carolina here in this.
It's God's country.
Yeah, there you go. Amen. We get that. I just want to say thanks for the hearing, and also today we're going to be hearing from a couple of folks, and from my part, one of my constituents, Mr. Stockton, as well, and I am pleased to be a part of this. Also, with what we've seen so far, and from my personal experience with the Georgia DNR, has been excellent. It always has been from my time in the state legislature. I think we'll see that again today. But I think there's a lot of questions that it does appear. What you said, Mr. Chairman, was dead on. That being outside of LA, letting people see what not only what we do, but also letting you know that the government, this is the checks and balances that we have. This is the congressional oversight. This is exactly what we're supposed to be doing. And serving on the Judiciary Committee and the Rules Committee, and also being on the OGR with you for a couple of years as well, it reminds us that's the part that I believe Frank has been forgotten in Congress many times, that our main role is oversight of how our tax dollars are spent and how our government operates. So I'm looking forward to the testimony question. With that, Mr. Chairman,
I thank you. I will hold the record open for 5 legislative days for any member who would like to submit a written statement further than where we are right now. We'll recognize tonight's first panel of witnesses. I'm pleased to welcome several attorneys who have all represented Operation Sumter Brewing defendants. Mr. Russell McLean, Mr. Alan Stockton, and Mr. Stiles is not joining us today, but I'd also like to welcome Mr. Charles Anthony Smith. Mr. Smith was acquitted of charges related to Operation Sumter Brewing. We thank each of you for being here with us today and look forward to your testimony. We welcome all of you pursuant to committee rules. Witnesses will be sworn in before they testify, so I'd ask you to please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Please take your seat. Let the record reflect that all witnesses answered in the affirmative. In order to allow time for discussion, we would ask that you would try to limit your testimony, your oral testimony, to 5 minutes, but your entire written statement will be made part of the record. And so we will go to our first witness, Mr. McLean, if you will give us your opening statement.
Thanks for this opportunity to speak today. 230 plus years ago, the American colonies secured their independence from the yoke of tyranny from the British Crown. The colonies set up a constitutional convention to create a document establishing our experience in a free constitutional government. Mr. James Madison was appointed to draft that document. Madison sent a copy of that document to Thomas Jefferson, who stated that we must have a Bill of Rights attached, which would establish our inalienable rights as given to us by our Creator to be free from government interference. Madison responded to Jefferson, stating that the Constitution is such a limiting document that it would not be necessary to have that Bill of Rights. On March the 19th of 1787, Jefferson wrote back to Madison, saying that the reasons we have to have a Bill of Rights is not to protect Americans from the abuses of legislative action, but to protect our citizens from the abuses of judicial discretion. After the Constitution was adopted, along with the Bill of Rights, Madison thanked Jefferson for his insistence on adopting that Bill of Rights. 200 years later, the United States Supreme Court has determined that the plain language of Article 3, Section 2 of the Constitution and the Sixth Amendment of the Bill of Rights does not provide a defendant with a right to a jury trial if the criminal charges only imprisons a person for 6 months or a fine of $5,000. The court further held that that was not a substantial deprivation of freedom or property. In 1996, the Supreme Court further held that multiple 6-month charges would not entitle a person to a right to a trial by jury. The court was wrong, and only Congress can correct this abuse of judicial discretion. No man should be in prison, not even for a day, unless he is convicted by a jury of his peers. When the federal courts can impose multiple petty offenses, exposing persons to months or even years of imprisonment, we must act to preserve the integrity of the judicial system so that citizens once again will expect to be treated not with tyranny, but with the grand experiment that our founding fathers envisioned. Another area of great concern to Congress should be the abuse of executive authority given to the federal and state agencies to conduct illegal covert operations with impunity. Operation Sumter Brewing is a prime example. Some of our federal courts have recognized this abuse of power, and Judge Sanborn said, and I quote, "The first duty of an officer of the law is to prevent, not to punish crime for the sole purpose of prosecuting it. In the present case, the chief endeavor was to cause and create crime in order to punish it, and this is unconscionable and contrary to public policy. When the criminal design originates in the mind of government officials, the government is stopped from sound public policy from prosecution." Our Supreme Court in 1958 held that public confidence is in the fair and honorable administration of justice is the transcending value of state. And the court further held that in the area of impermissible police conduct, the protection of our functions and the preservation of the purity of its own temple belong only to the court, and it is the province of that court to protect itself and the government from such prostitution of criminal law. In recent years, our district courts have held that the function of law enforcement is the prevention of crime and the apprehension of criminals. Manifestly, that function does not include the manufacturing of crimes. The courts have held that it is not the role of the judicial branch to rubber stamp whatever imaginative devices agencies dream up. It is the duty of the courts to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all of the reservations of the particular rights and privileges amount to nothing. And that's quoting Alexander Hamilton in the Federalist Papers at page 78. These reverse sting operations transcends the bounds of due process and makes the government the oppressor of the people. A review of these cooperative agreements in this case you will be presented with and have been presented with show that it was not until after the investigation of these men, these documents were ever even signed. The operation was conducted for 4 years without a specific interagency agreement between the federal and state agencies, and there is nothing in these agreements that authorize or allow the federal or state agencies to engage in the multitude of crimes that these undercover officers committed. Thank you.
Thank you, Mr. McLean. I would ask, as much as you may agree, I'm going to need to ask you to silently shake your head instead of doing applause, because this is, it wouldn't be condoned in D.C. I can't condone it in Haywood, and so if you would do that, you can just kind of do the nod, all right? And I'll make sure that we recognize that. Mr. Stockton, you're recognized for 5 minutes.
Congressman Meadows, thank you so much. I can't remember what small town it was. I don't know if it was Bryson City or Robbinsville or whatever when I first met you, but you've talked straight to us ever since then. You said, I'm going to do this, and I didn't really believe you to begin with, but you followed up on what you said you would do, and I appreciate it. You were also very candid with us. You said, look, I know all these folks aren't Billy White. You told some personal examples and everything, and you were exactly right. This isn't a situation where you have a mass of innocent, lily white people that were falsely accused of stuff. What Operation Something Brewing is, in a nutshell, though, is probably the largest mass misdemeanor operation in the history of law enforcement. I've never seen so much invested in a crime which our society and our laws holds at the lower end of the spectrum. This was a situation where, and just to give some background, I have a client right now on death row. I have had clients tried in the federal courts for major drug trafficking operations. I've never seen the amount of law enforcement effort expended on any of these cases that I've seen on Operation Something Brewing. And my experience with Operation Something Brewing involved 3 clients. One of them was absolutely innocent. She's a mid-40s accountant. She happened to be dating a person who was a target of the investigation in Georgia. Although that person, he's here today, Edsel Brent Thomas, his part of the investigation had nothing to do with North Carolina, had nothing to do really with bears, and basically what it involved, and I'd also say it's in my statement, he has one arm. It involved him riding around with 2 undercover agents, one of which was a North Carolina law officer, undercover wildlife officer. The other was a Forest Service officer from North Carolina, riding around at night, shooting deer with a spotlight. My understanding is 5 were taken, only 1 by Mr. Thomas, the other were taken by the undercover officers. Keep in mind, Mr. Thomas has 1 arm. It's impossible for him to both hold a light and shoot a deer at the same time. That said, you brought up Operation Smoky. That was a legitimate, apparently, operation. I remember that. I was a much younger person. There was apparently trafficking in bear parts and so forth. Fortunately, with the advent of Cialis and Viagra, we don't have the market for bear gallbladders anymore. That's no longer something that can be marketed or is marketed. But nevertheless, that is something that was used as the impetus for this operation. If you look at all the different press releases and the justification behind this, it was, we need to stop this organized commercial bear hunting and selling of bear parts and so forth. And respectfully, that's not what Operation Something Brewing showed. Operation Something Brewing, basically what it showed was the investigation wound up exceeding its authority and its mission. There were not one instance I'm aware of any bear part or animal part being sold or even discussed. There were no felony convictions whatsoever arising out of this, and there was no evidence of organized poaching. Clearly there were some misdemeanors committed in this. Most of them I would submit instigated by law enforcement. Not just instigated, but actually committed by law enforcement, and the people that were with them got painted with the same brush as the officer committing the crime should have been painted with. One in particular who's here today, Chad Crisp, was not even a target of Operation Something Brewing when they conceptualized it. They came up with him when they went to a convenience store and said, we want to go bear hunting, who's somebody we can talk to? So this, respectfully, I've said this before, it was more of a solution in searching for a problem. There was not the problem with the bear poaching that was portrayed when Operation Something Brewing came about. And I'll echo Congressman Collins' statements about the Georgia DNR and my limited dealings with this. The Georgia DNR weren't the problems. Of course, that's just my limited dealings with this. Most of what I saw were at the federal and the North Carolina state level. But that's just, those were my cases. I'm sure there were problems with Georgia DNR, maybe on some of the other cases, but not in mine. As Mr. McLean said, I'll end with this. Probably if anything can come out of this, I would hope that maybe at one point in time, someone like Chad Crisp, who is facing a 20-month sentence, will be entitled to a jury trial for that. He was not allowed a jury trial, and his case was at the federal district level and was removed after he was acquitted on the first felony charges. They removed it, put it in federal magistrate court because they knew he wouldn't get a jury trial and they knew he would get loaded up on time. If anything could happen, I'd like to see something be addressed so we have that right. Thank you.
Thank you, Mr. Stockton. Mr. Smith, you recognize for 5 minutes.
Thank you, Honorable Committee. I'm Charles Anthony Smith, one of 10 people in Haywood County charged with doing Operation Something Brewing. I was charged with 17 misdemeanor violations. In September 2013, I was tried in the Special Sessions District Court. After 2 days of hearings, charges were dismissed due to insufficient evidence. In other cases, charges against 3 other people were dismissed due to not having proof beyond a reasonable doubt. And in June, charges against 3 other men were also dismissed. During my hearing, evidence presented was a recorded phone call with North Carolina officer Chad Arnold, who posed as Chad Ryan. The call was about running his dogs on private property in the Silvers Cove fox pen. There was no conversation whatsoever which involved bears. During my hearing, Officer Arnold testified he never saw me at Silvers Cove, nor did he know of my whereabouts, or even if I was in the country on the days he was running his dogs. Yet, while he released his dogs, he charged me with the violations. I learned that I was involved in an investigation on February 20th, 2013. There was a knock at the door. I answered the door, and about 15 officers shouted search warrant. They grabbed me by my arms and pulled me out of the house. Then the officers pushed past me, entering the house with assault rifles wearing bulletproof vests. One officer had a handful of papers. He didn't take the time to show them to me. I was terrified because I was at home with my 9-year-old daughter. I told them that she was inside and asked them to let her come outside to be with me because she would be very frightened. My thoughts were that she might get up and run, or she could be harmed or even shot. I repeatedly pled to be with my daughter, and every repeated request was ignored. While the officers searched and held me, I asked them if I was under arrest. They replied no. The officers kept pushing me into the driveway towards their vehicle, and I was placed inside the one in question. But I would not answer their question, but I did ask them to bring my daughter out to be with me. One officer was Jenny Davis, Special Agent, U.S. Forest search. She asked if there was anyone I wanted to tell on, and when I did not, she placed me in handcuffs and arrested me. My neighbor picked up my daughter. I talked to my neighbor later. She said my daughter was sitting on the couch with several officers in the room, some sitting on the couch. My daughter told me they asked her a question and then she was very scared. During the time I was in jail, my wife told me she and my oldest daughter went to the residence to find out what was going on. They found the property a swarm of multiple officers and 10 to 15 vehicles in the driveway. They approached the resident and were told that I had been taken to jail and to wait to talk to the officer in charge. The doors were open, officers were in and out, property was being placed in brown paper bags and removed. The officers never came, so they did enter the house. The officer told them to log in their computers demanding passwords. They told to stay with the officers, and when the officers asked questions, they told that their answers would be assumed by these officers. They observed officers photographing documents which were confidential. When search teams left, they did provide a copy of the search warrant and a copy of items seized. We determined items seized that were not listed in the affidavit to be seized. They did not list a legal list of damaged or broken items or a list of documents photographed. There are many things that seems and feels to be against our rights as citizens and private property owners. The search, the arrest, and the charges seem to be very wrongly handled. The officers themselves reported I was not violent, yet they stormed the house like a SWAT team. So far, as a result of Operation Comfort Brewing, I have learned several things. I have learned by North Carolina Officer Chad Arnold's testimony under oath in the court of law that wildlife officers can kill bears illegally, can kill bears that are underway, can buy chocolate paste and put it in an individual's yard, can drink alcohol in the capacity of doing their job, can dig ginseng on national park, and commit other crimes, other wildlife crimes and violations, and charge other individuals for the crimes that they themselves have committed. I have also found that officers can join in with other agencies and conduct investigation on hunters across state lines before an interagency agreement. Officers can break laws filed alone and then show up with dead bears and charge hunters with these violations. They can secure search warrants for property where no known crimes have been committed. It appears by Arnold's testimony that the bear posting exists within those agencies. While the misdemeanor charges against me were dismissed by the judge, the trauma to my family, invasion of my home, our lost feeling of security, the damage to our names and reputation by things published in the papers, on TV, and on the website, these things should not be dismissed. Steps should be taken to protect others from events such as this. Because of this experience, I am asking the individuals who have the authority and the power to please go on our behalf and stand in the gap to protect our families and others from officers' actions such as these. Thank you.
Any testimony? The chairs want to recognize the gentleman from South Carolina for a series of questions, and we'll go to the gentleman from Georgia, and then I'll follow up. The gentleman from South Carolina is recognized.
I thank the chairman and thank you for your testimony. I noticed in some of the documentation that one of the defendants pled guilty to 6 offenses and received for that guilty plea 20 months in prison since the prison sentences were added consecutively. Now, this was in federal magistrate court. I guess the question I would have is, and I look at what he pled guilty to: knowingly operating a vessel on the waters of the state of North Carolina between sunset and sunrise without the use of navigational lights, knowingly intentionally hunting bear at night and during closed season, knowingly intentionally hunting deer at night, knowingly and intentionally hunting deer with use of aid of artificial light, knowingly and intentionally hunting without a license, knowingly and intentionally hunting deer with a firearm during closed season. Those look like state game law offenses, not federal offenses. So he was tried in federal court and given a pretty stiff sentence because they were added together and run consecutively, not concurrently. The question I have is, do you think Mr. McClain and Mr. Stockton, being attorneys, do you think that that would have been the sentencing, had he been convicted, pled guilty in state court? Jury trial or not? In a state court?
I know it would have been, plus we'd have an opportunity to have a jury trial in North Carolina. That's the critical key.
But you set that aside, I agree with you on that, okay?
He would have gotten a probationary sentence, paid a fine of about $2,000 and gone to the house. And let me tell you something. He was facing 37, 34 charges. So he was facing almost 18 years in prison. I guess you'll say the Pope shot Barry if he wanted him to keep him having to do that much time. People sometimes plead to stuff they didn't do in order to keep from having the harsher sentence imposed on him. That man, I didn't represent him, but he was facing 34 counts.
Mr. Stockton, you agree with
Yes, and this particular person, his charges were moved from,
pull that mic, because folks in the room need to hear you.
his case was moved from federal district court, where he had just been cleared on felony charges in front of a jury trial. And instead of trying the rest of them to a jury, they moved them to a judge who has treated us with utmost respect and been very decent and hasn't ever found anybody not guilty that I'm aware of. But they moved those charges to his court, and he has propensity for giving jail time, and that's basically the deal they worked out. And it's just he made the best of a very bad situation.
I'm not familiar with this individual. Let me ask you this. Were these charges, crimes that he committed, were they committed on federal land?
Some were, some weren't.
Some of the ones that the gentleman that pled guilty, they were on federal land? 3 of the charges occurred on one hunt. In other words, that he went hunting one night with a wildlife undercover agent, and they broke it down to whatever happened to be in the woods they charged him with. You know, if there was a bear, if there was a deer, they didn't even see anything, but they charged him with each violation, even though he didn't shoot a thing. It just happened to be there on one night, and that got him 15 months in This
prison.
individual that we're
Yes, sir.
talking about?
Yes, sir. One occurrence got him 15 months in prison. One hunt got him 15 months.
Mr. Chairman, emails provided to the committee appear to indicate that the magistrate judge in this Western District Court received a directive from the chief judge that individuals sentenced for petty offenses are not to receive probation.
That came from a U.S. attorney.
Wow. That's amazing. I'm going to have some other questions. I want to yield back and hopefully have a second one.
The gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. I think following up, and I want to go through some basically your testimony here, just interesting points that are concerning me. Concerning, it was just pointed out, I think, I serve with the district committee, so this falls in line on the other side. The state consent, I've already contacted Mollis in D.C. about interaction with this criminal justice issue. We'll talk about this. Let's go back for a second. Mr. Stansel had charges pending in Reagan County.
Correct.
To DA, Rickman?
Yes.
Those were dropped because of the prosecution on the federal, correct?
Yeah, he had warrants taken out on him. He's actually never been arraigned on those charges. Mr. Walt Stansel, Mr. Kel Stansel, wound up pleading to 2 misdemeanor charges in order to get the felony federal stuff dropped. Yes.
Rickman handled those cases, correct?
That's his office did. I think it's actually.
Now, it is true, and I'm asking this, Walter Stansel was found guilty by U.S. District Court for violating Lacey Act. Now, did you represent him in that case?
I did represent him on that, but I think respectfully, I think the way to put that is he was found not guilty of committing a felony Lacey Act violation.
Okay.
He was found guilty of what we told them we were guilty of. He had a bear bait that he had legally maintained for years for training purposes. In North Georgia, we have a training season. It comes in 3 times a year. And there were 2 Georgia DNR officers who testified in his case. And I would submit, as far as I knew, everything they said was very credible and truthful. And one of them, I think it was Jesse Cook, he basically confirmed that what Mr. Stansel was doing as far as maintaining those bear baits for training purposes was legal. Mr. Statson broke the law, though, when he allowed Chad Arnold to go up there and hunt one of them. And respectfully, that was the first time that had happened. And had he known the full situation that Chad Arnold had killed a cub a few days before, that wouldn't have happened then. But we told the jury to begin with, that's what he did. And that's what he did in Georgia. And that's what he's guilty of.
And I think that's interesting because some documentation we provided by agencies actually did not go into that kind of detail and actually just said he was guilty of this jury trial. So I want to focus that. Let's go back to that for just a second. The issue of this camera, there's another issue out there. Let's go back to that one because I think that one is, this one disturbs me. Okay? Private property, a camera is placed. Was there ever a warrant or anything ever produced for that?
No, and more importantly, it's private property that a U.S. Forest Service law enforcement officer placed in a relatively large piece of private property up near between Scaly and Highlands.
I know exactly where we're at.
And it was placed in the middle. And I included in my statement basically what I had the statement of facts from the appeal. So if it kind of reads legally, I kind of cut and pasted. But anyway, that situation is bothersome because he was convicted, and Walt Stanson just had his 49th anniversary last week. His son's an ordained Baptist minister. He's had one speeding ticket in Louisiana, so I don't even know if that counts. But that's the only thing he's ever done in his life that was contrary, that he's been convicted of or whatever. But he finds a camera, a surveillance camera, a game camera. It's not attached to a tree. It's laying on the ground. It's got, I think the evidence was there might have been a stick or something under it.
Well, let me just interrupt you, Richard, because I think this is important. I'm going to ask this question to the second panel coming as well, because this is a question of why this got there, number one, is trespassing, number one. Number two, there's another issue here. But it said, and I'm believing this is part of your cut and paste from the actual testimony, Officer Souther testified that he had placed one of his business cards inside the surveillance camera. I think this is an important point.
Yes.
It said he placed it inside the surveillance camera, but yet Officer Sutter later in the agreement agreed that Walter never opened or disarmed or turned off the camera until after he left Jack Billingsley's home. Again, if you walk up upon this on your yard, I'm born and raised in North Georgia. You come on my yard without reason, my dad's state trooper in the state of Georgia. We'll get that out of the way real quick. I've fought the law all my growing years. Some of you get that on the way home today. I get that, but we're going to investigate this further. But when basically there's no marking, at least of what is shown, and contradict your testimony. I've also looked through the interagency agreements. I'm not sure where they would find this or whether again, this was above all the other stuff. Undercover investigative work is a needed valuable tool of all agencies. But this one gets at the heart of I think what a lot of people in this room are very concerned about. And that is, where does that line get blurred when you go on private property off a road that, and really have no idea. Even if you put a big red, white, blue sign that says this is the federal government, I want to know why you're there to start with. Or a court had better allowed you there. And I think that's the problem. Mr. Chairman, how do you go back?
I thank you, gentlemen. Mr. Smith, I'm going to follow up with you soon. Am I understanding your testimony correctly? That you got a phone call.
Yes, sir.
Someone asked you if they could run dogs in an area that it is legal to run dogs to train for fox hunting or whatever, and you said it's okay to go there. Is that correct?
Yes, sir. It's this Silver Scope fox pen has been a fox pen for probably 50-some years, as far as I know. Probably way longer and older than I am. There's been dogs up there. This is not a place where they do any killing. It's a four-sport dog exercising facility only.
So when the officer asked you if they could do that, I mean, was he inferring that he was going to do something illegal or hunt or anything like that?
No, sir. He just asked for a date that he could run his dogs. There was a little cabin up there that had a calendar on it. I didn't own or lease the land. There was a little calendar up there that people just write their names down on when they wanted to come and run. And it was...
So showed up at your door?
Oh, in my place on Medford Code, probably 20 to 25 agents from 5 different agencies.
And your greatest crime is that you gave advice on a telephone call?
Yes, I don't even see how he was able to get a search warrant. He didn't in Haywood County, he had to go out of county to even get one. And I don't see how he even got a search warrant just placed on a phone call. That's concerning to me.
So let me tell you, let me ask you the other part, because what really concerns me is when you talk about your 9-year-old daughter.
Yes, sir.
I start to put myself and think about my kids when they were 9 and 10. And so they took you outside,
Yes, sir.
and you kept asking, well, just let my daughter come out.
Yes, sir.
And their response was no.
They never did acknowledge me asking for my daughter.
So they ignored.
Yes, sir.
So, but they don't refute that you asked for your daughter to come out. When you had this, they didn't say that you
They
didn't.
never
say
brought it up in court.
Okay. Did you bring it up, or did your attorneys bring it up in court?
I think Mr. McLean did.
Well, Mr. McLean, did you bring that up in court?
I brought up a lot of things on top of that, yes, sir.
Okay, all right. So Mr. Smith, when we see this, do you believe that the type of what I would refer to as SWAT team kind of swooping down, do you think that that was disproportionate to the crime that you were even charged of?
Yes, sir.
So what kind of lasting effect has it had on your family? You mentioned that a little bit in testimony. What kind of lasting effect?
It's hurt our reputation of our name in the community.
Because they think you're guilty because you were charged.
True. And just all the media sensation that they had over everything was just, it was just totally uncalled for. And the conduct of the officers at my house was outrageous.
Outrageous in what sense? I mean, obviously, there's a number of, we want to make sure our law enforcement officers are safe and.
All it would have took, if they would have needed me to turn myself in, it would have took a phone call, and I would have gladly brought myself right up here to the courthouse, to the jail. It wouldn't have took 25 officers to come to my house with bulletproof vests and assault rifles to get me to turn myself in, or for them to apprehend me. It would have took one phone call. I'd have been up here as quickly as I could have done something with my daughter and got her safely somewhere.
Mr. McLean, let me come to you since you talked about these charges. I think it was mentioning where there were 3 different charges: hunting a bear, a deer, and a hog with a spotlight, but it was one time.
December the 3rd, one time.
All right. So did they have different kinds of shells for the gun that particular night? Because
In fact,
maybe in DC they don't understand that perhaps you use a different shell to hunt different kinds of animal. I mean, obviously you could possibly find one that would work for all 3, but you don't normally go out hunting for all 3 of those.
no, the undercover agent had one gun.
All right, so the undercover agent had a gun. Did the person so your person didn't have a gun,
But he went with
but he had a spotlight and went with it.
Had a flashlight, yes.
Had a flashlight. A flashlight?
Big lights.
Oh, okay, so it was big flashlight.
Pretty good size flashlight.
So here he was out there, but he went out, and so he got charged with 3.
Whatever they could think of was in the woods that night, they charged him, and he ended up getting 15 months because they didn't see anything.
Well, they didn't charge him with grouse hunting.
Oh, yeah, I don't think there's any grouse out there.
Oh, that's what it was. So if we're doing that, you mentioned how many charges?
He had 34 charges, and I want to say this about that, if you don't care. One of your U.S. Forest Service officers specifically told Mr. Stiles, I wish he was here because he's the one that came down and related to us. He said, look, you may win in district court in front of a jury, but we're going to take you in front of a magistrate, and you'll get time. And that's what Eric Stiles would have told me if he'd been here. So he was facing that going in. And that man knew that he had 34 charges, and that was, in my opinion, almost 18 years in prison. And so he opted to do what he had to do to keep him getting as much time as they wanted him to get.
So 34 charges, and if you added the maximum sentence for each
Months charge.
so that would be how many years?
Well, I'm not good at math, but take 6 and divide it into 34, and I'd give it, so it'd be half of that.
17 years.
17 years,
All right,
good.
all right. Well, thank you.
I'm a lawyer, not a mathematician.
Well, sometimes being a lawyer is better than being a mathematician, so I'm going to yield to the recognized gentleman from South Carolina for a second round of questions.
Thank you, Mr. Chairman. So thinking about, I want to go back to something that Congressman Collins mentioned, and that is federal officers coming on private land. Now, I realize in South Carolina, game wardens working for the wildlife department can enter private land even without the necessity of showing probable cause, without a warrant if they are trying to enforce game laws. They're coming to see if you're baiting deer, turkey, if you baited a waterfowl hole and all that, they can come on private land. I get that. I'm real fuzzy on whether a federal officer can enter private land without a warrant, because my gut and my understanding of constitutional law says no. So I would like to some clarification there. Was a warrant issued? Was there, due to the joint jurisdictional operation, was there an agreement? And the other question I had is probably for the second panel is, when I was a legislator in South Carolina, we were approached by U.S. Forest Service law enforcement officers to give them the ability to handle Title 51, which is our criminal code in South Carolina, offenses. And so if they saw someone breaking a South Carolina law on U.S. Forest Service property, they had the ability to enforce South Carolina law on federal Forest Service property, federal land. But I don't remember anything we did in the state giving those federal officers the ability to enforce either South Carolina law or federal law on private property, non-federal land without going through the normal warrant process. And so that's just a question I throw out there because I'm real concerned about what Representative Collins said.
The particular officers you'll be talking to shortly will tell you that they had an agreement signed in '06, what's called an interagency agreement. But all that basically did was deal with federal wildlife violations such as the Lacey Act. It didn't provide that they had the right to go enforce South Carolina laws on private South Carolina or on Georgia property. And it required in the '06 agreement that they had to have a specific interagency agreement before they could even get involved in those types of activities if they want to go undercover, covert operations. So that was the premise that they tried to claim that they had the authority. Then when I asked for the written authority, they signed it a week and a half after they started charging all these guys and picking everybody up. All of a sudden it came up and it was signed by all of the agencies. South Carolina actually did participate in some of these activities, but they realized what was going on, I think, and they dropped out of this. Georgia stayed in, and so did Kentucky and some other agencies, but South Carolina came out.
So just for clarification purposes, going back to what Representative Collins was asking, did a Georgia wildlife officer or a North Carolina wildlife officer accompany the federal officers as they entered private land?
No. And
It was federal only.
Well, when Mr. Stanton's situation with private land, there was, on occasions, state officers, North Carolina state officers that entered with him. It's clear in the statements and everything, though, Forest Service officer Ryan Southern said, I made the decision to do this and everything. In Reagan County, Georgia, where I'm from, 65% of the county is owned by the U.S. Forest Service. They got plenty to look after on their own. And it's a similar situation in western North Carolina there. I don't know why the U.S. Forest Service, and this wasn't just any governmental agent that did it, it was a U.S. Forest Service person that strayed off of their thousands and thousands of acres to surveil something on 50 acres. And you're right, in Georgia, I think we're pretty much the same way about an officer, a conservation officer can enter on, check, see what's going on. But I would submit there's a difference between checking for compliance and surveilling somebody. I would submit they should have had a warrant, they should have had permission, they should have had some kind of, in the situation with the Forest Service ranger, he should have had some kind of jurisdiction to go there. Like I say, if he's putting that camera on federal lands, that's one thing, but he was putting on private property.
It was strictly investigating on private property. It wasn't an instance of transiting private property to get to federal property. This was uniquely,
And I gave you too much information in my statement, if you read it. I spell it out from the time you leave the state road till you get to where this was. You don't traverse any federal property at all. And keep in mind, in his trial, all the testimonies from the officers, everything you see is based on the actual transcript of that trial that I've written there. And the officers themselves stated, look, it's probably a quarter of a mile from the nearest U.S. Forest boundary. You cannot see a U.S. Forest Service boundary from where we're at. You don't cross the U.S. Forest Service. No, this was a wholly contained private piece of property.
do you think this was an instance, and this is just for my edification, of baiting or luring animals off of federal property onto private property?
That was probably the argument. Keep in mind, though, there are legal instances of baiting. There are legal ways of baiting. This had been surveilled, and candidly, there were no baiting cases made out of this. The case that was made out of it.
I'm not familiar with North Carolina and Georgia laws. You can bait in South Carolina all day. It's the hunting over bait that trips you up. If you're luring animals to hunt, and so I can put bait out to view wildlife and photography and all kinds of things. It's the hunting aspect, taking a game over bait, where the law kicks in. So, I appreciate that. Let me move on, but in the essence of time, I want to talk about the Lacey Act a little bit, because during Operation Something Brewing, federal Lacey Act violations could apply if a bear or wildlife was illegally killed and then transported across state lines. According to media reports, undercover officers, against the advice of hunters, called hunters from surrounding counties to try to get them to participate in illegal selling of bear parts, such as gallbladders. Hunters refused to take part in this illegal activity, and according to news reports, no charges were filed in Something Brewing related to gallbladders. So, related to gallbladders, there was no Lacey Act violations. This seems like a huge federal effort, using the Lacey Act as the impetus for that, to prosecute and investigate hunting activity in North Carolina, Georgia. And at the time it was developed, South Carolina was brought into it for at least the initial discussions. No cases or no investigation were done in the state, but they were initially contacted. So it seems like a tremendous effort.
To give some background on the Lacey Act, it came around at the turn of the past century, around the early 1900s, and it was at a time when the birds in the Everglades were just being decimated because of women's hats. That's basically part of what brought the Lacey Act around, and it was about fighting the commercialization of animals. What's happened now is, and the way the Lacey Act, I guess, applied in our situation is, you've got a situation that Mr. McLean's client was a licensed hunting guide, and they consider that selling the animal, or selling the animal. In my client's situation, he wasn't part of the commercial operation, the outfitting operation at all. He allowed this undercover officer, and there's no testimony, no evidence whatsoever that my client ever received a dime, but he allowed him to hunt at a place where he had been maintaining legal bear baits for training purposes. It became illegal the minute he allowed him to go there. But the way they bootstrapped him into the Lacey Act is, he knew or should have known that bear would eventually cross state lines.
Does he have a crystal ball?
That's what it would take.
That's the thing.
That's what it would take.
Nothing, basically, the game warden state game warden in North Carolina went to this bait site by himself. Nobody else was there. My client wasn't even in the picture. He shot the bear. He then called his client to come back and help him load it, took it to my client's property in Georgia. They skinned the bear, and then he brought it back, the wildlife officer brought it back across the state lines in order to get the Lacey violation.
The next day.
The next day.
Well, Mr. Chairman, I don't want anything to be construed that I'm against the Lacey Act. I think the Lacey Act has very immense value in this nation with regard to hybrid, with regard to a number of other things. I fully support that. I do understand the history of the Lacey Act, the Bird Treaty Act, and what it did for conservation protecting certain species. And so, but I am concerned about what I'm reading and hearing about how the Lacey Act was sort of the impetus for the whole operation, and there weren't any violations. There wasn't any evidence that I've been able to see that the Lacey Act was, egregiously being violated. So I thank the chairman and I thank the witnesses, and I'll yield back.
If I may just real quick, the Lacey Act situation, my client was charged in North Carolina for a felony in federal court for a Georgia violation, a Georgia misdemeanor violation, and that misdemeanor was the predicate for a potential felony conviction. That's the situation we have.
Chair recognizes the gentleman from Georgia, Mr. Collins, for a second round.
I'm not going to, there's a lot's been answered, and I think Joe in South Carolina answered, and really brushed up a lot of things. I want to use some of the times that congressional hearings, not only on a specific issue, give you a chance to make a statement, but also clarify, maybe teach you. I may not like this, Mr. Dodd and Mr. McLean, we have, is among many times defense attorneys, but we always represent innocent. We know because they're not innocent. But one of the things that's talked about, and it's been talked about in this administration, there's been a discussion in this country for about 8, 9 months now about prosecutorial discretion. In fact, our president has said that he's acting under prosecutorial discretion by just basically saying, I'm just going to take 5 or 6 million people and say, I'm just not going to prosecute the law. That's not prosecutorial discretion, that's just against the law. Okay? But what we're seeing here, and I'm going to make this clear because in fairness to our prosecutors and in fairness to our system, the issues here in which I've had cases in which I've had multiple charges, and it's up to the prosecutor to decide really what they want to go forward, how much they want to charge or how less. Would you not both of you agree that is prosecutorial discretion?
Correct.
In the pure sense. So, and really, as much as we may or may not like it, they can in some ways choose the form in which they're going to charge these crimes, correct?
Yes.
Okay. I think that's the hard part to understand. This petty offense issue, I think, makes it very difficult for people to understand. But I think the bigger picture is, and I want everybody here to understand this, and maybe you're going to be watching later, those of us who got really upset with this administration for claiming prosecutorial discretion in an immigration issue, in which they're just blanketly saying, we're not going to touch this because we have the ability to pick and choose which laws we want to enforce. That's not what happens a lot of times in these cases, which are actual prosecutorial discretion. Whether I may not like it or not, frankly, is irrelevant. They do have that. But I do want y'all to expound upon that because you both mentioned in your testimony, and I'd just like to hear your comments on it.
And I appreciate the fact that they have prosecutorial discretion. My position is even beyond that. If you're going to prosecute me, at least give me a right to go in front of 12 people who are my peers to try to see if that prosecutor can get a conviction, because my client is presumed innocent whether he chooses to prosecute him or not. I believe that every man who faces any day in jail should have the right to have a jury. If we'd have lost every one of these cases in front of the magistrate because they wanted jail time, then we wouldn't be sitting here, in my opinion. But they denied something that's even far greater than prosecutorial discretion. They denied every man in the magistrate's court the opportunity, because they knew they were going to get time, to give us a jury trial, to let the jury make that determination.
Well, I think the issue you bring up there, and this is to continue this series, and it's something, like I said, I already said in my first line of questioning, is this concern of, especially consecutive, because many times people are charged with multiple, because of just the nature of the event. It may be petty, but it's multiple, and if done consecutively and not concurrently, it presents an even larger issue, and I think that's what you're pointing at.
And my point is also, I respect one of our district court judges by the name of Cotton. He's a district court in the Middle District of North Carolina. Let me tell you something. When he was a magistrate in the 80s, when he realized that the government wanted active time, even one day, he would require that prosecutor to bring a jury in a magistrate's court and let us try it in front of a jury. And that's the thing that I think Congress really needs to look at and change.
What's up the law? Ms. Stockton, want to add to that?
Well, just when you were saying that about prosecutorial discretion, it just kind of reminded me of the movie Cool Hand Luke, where he said, look, calling it your job don't make it right. And that's kind of the situation. Just because they're saying, look, it's our job, that doesn't make what's going on here right. like I say, this isn't a situation where you've got a lot of lily white people, although there are some lily white people in this situation. In my statement, I hope y'all will pay attention to C.J. Junaluska. He was a victim. He was an absolute victim because he was indicted on a felony in federal court on a lie. Absolute lie. No other way to put that. And it was ultimately dismissed, but only after you had to worry about it, and I think you had to hire a lawyer to do it. Cindy Clanton was indicted. I'm not going to say it was on a lie, but she just didn't do what she did. I mean, do what they said she did. She was just completely innocent. Jack Billingsley, who's here today, he was charged and ultimately dismissed, and he was just innocent. Like I say, calling it their job to bring those charges didn't make it right, because they put some people who had not committed crimes in a bad situation. And I represent a lot of hardened criminals that, they thrive off that kind of rush, that kind of drama. But your average law-abiding people, even though it's relatively a minor misdemeanor, maybe in some case, that's a huge issue to their life. People's good names mean something to them. Walt Stan Smith means something to him that he's got a clean record. It means something to him that he can tell his grandson that, look, I'm not being convicted of any crimes or whatever. And they're making more out of this than what it ever was.
So I think the biggest thing here, having respect for my background, from the state legislature and all, and basic family background, as far as that we need law enforcement and we need good attorneys on the other side. So it's the balance that keeps the system operating. When those balances are missed and those balances are off kilter, that's when people lose faith in the system on both sides, and we need to continue to maintain it. And I also just want to say, Ms. Smith and Mr. Meadows has done a good job asking questions, but I just want to thank you all for your testimony, and I appreciate you.
I thank you, gentlemen. I'm going to go ahead and conclude with a round of questions, and then we'll make a very brief adjournment for the second panel. But Mr. McLean, I want to come back to you. You had indicated earlier that the agreement that basically authorized this was not signed until, did you say 12 days after some of the charges?
Just to be on the safe side, let me look, I brought it with me.
You actually brought documents with you.
Okay, apparently the U.S. Forest Service signed it on February the 23rd, and it looks like that the state of North Carolina signed it on February the, I think it's 28th. 2012, I'm sorry.
And this was after,
I'm arrested on February the 19th.
so it was after Mr. Smith was arrested.
And all my other clients too.
So are you suggesting that these agencies knowingly entered into arresting someone without having the proper documentation?
I guess the judges will have to deal with that.
I'm saying, are you
I
suggesting?
believe they are.
Okay.
I believe they didn't have the authority to do what they told me to do.
All right. So one of the things that was real troubling to me early on, and why it raised, I guess, my sensitivity, is I heard a number of different stories that were they just didn't seem like it was America. It just seemed like they were going a different direction than what our founding fathers. One of those had to do with an email that basically said, we're going to give people jail time instead of probation because I guess it's cheaper. That's what they said. Now, does that make sense to any of you on the panel, that it's cheaper to put somebody in jail than give them probation? Now, under what theory is it cheaper to do that? Mr. Stockton?
Well, I think it depends on what you're signing the value to. If you're saying dollars and cents, maybe you can do some fancy accounting and come up with it being cheaper. But
So it's cheaper to feed them and house them
But if you're looking at the cost in liberty and justice, then it's definitely not cheaper. That's the wrong way to go.
Okay. Well, I do want to make mention of Mr. Frank Whitney. He is the Chief United States District Judge. Because when some of this stuff came up, I made a commitment not only to some of you, but some of the people in the audience here that I would follow up personally. And I will say that I called Frank Whitley, the chief judge, and made him aware of the emails that I had received. It was of great concern to me because it appeared as if we were intentionally trying to put people in jail instead of actually allowing them to either pay a fine or probation. And much to his credit, I guess the day after my phone call, he put forth a clarification memo that I think now that you've seen, that says, you haven't seen it, but you're aware of it, that says that we should have all the options. They shouldn't be forced into jail. And so I guess my question is with this clarification, do you think the ambiguous nature that was there prior to that entered into, in any way, as a factor in terms of sentencing for any of your clients as they went forward? In any way?
I don't think I can speak to that. Just truthfully, I don't believe I can.
All
You would ask me to step into the minds of those justices and those judges, and
right, fair enough.
I can't do it.
I got to say, I think that law enforcement officers in this knew where they could get the most bang for their buck, and they moved from the district court to the magistrate court because they knew there wouldn't be probation.
So what you're suggesting then, Mr. Stockton, is that there were charges, felony charges, all these other charges that would allow for a jury trial. And then they saw people getting off of a jury trial. And they said, well, let's just do away with all of these that require a jury and let's recharge them with a misdemeanor where hopefully the result is a little favorable. Is that what you're saying?
I believe in my heart that's exactly what the situation is. But I'm saying that based on the knowledge I have of what Brian Southern had said to Eric Stiles about we'll just move it down to magistrate court and they'll give you time. That's why I say that. You'd asked Mr. McLean earlier if he believed that law enforcement had deliberately arrested like Mr. Smith, knowing that they didn't have the interagency agreements. I don't want to assign ill motives to anybody without good reason, because that's what's been done to us. That's what's been done to our clients. Sure. I can only assume that that was negligent, not intentional. But on this situation, absolutely, they moved in. We're talking basically about Chad Crisp case and his father's case. They basically moved those from the district court down to the magistrate court to load them up.
All right. So let me see, if I were speeding on a federal highway, Blue Ridge Parkway, I guess that would be a federal misdemeanor. So if I was speeding and they caught me 3 times on the Blue Ridge Parkway, could I, under this same scenario, go to jail for 18 months?
And I'm not completely sure if a speeding ticket in the federal system allows for
You
that.
get 5 months is what you're saying. Well, that's encouraging. All right, I think we get the sense of it. I'm looking forward to hearing some of the answers from the second panel. Obviously, I want to thank each of you for your time, for your testimony here today. And we are going to take a short break as we seek the second panel of witnesses.